Good evening and welcome to the inaugural lecture of the Robert A. Katzmann Annual Symposium Series. I'm Trevor Morrison. I'm the Dean here at NYU School of Law, and it's my pleasure to welcome the great many of you, over 3,000 we believe, who are joining us for this webinar for this evening's event. The idea for this event came from its namesake, our dear friend and colleague, the late Robert Katzmann, longtime judge and then chief judge of the U.S. Court of Appeals for the Second Circuit, and for many years, one of the country's most important thinkers about the role of the courts, their relation to other branches of government, and their capacity to deliver justice and preserve the rule of law. Among his many myriad activities beyond the bench, Judge Katzmann taught for many years here at NYU as an adjunct instructor. He was, of course, an outstanding teacher, much beloved by his students. And after he took senior status last year, Judge Katzmann assumed a more substantial role at NYU. We envisioned it as involving even more teaching, as well as leading a number of other initiatives outside the classroom. And one of those initiatives was his idea to establish a new annual lecture here at NYU Law, featuring legal jurists, public servants, legal academics, and others who on an annual basis would address pressing issues in law and policy, especially as they relate to the broad topic of the rule of law. The idea was to make the lecture a key fixture in the intellectual life of the NYU law community and the legal community more broadly. We were terribly excited about it. But Judge Katzmann wanted more than simply an annual lecture. His vision included study groups, which would dig deeply into the ideas advanced by each year's lecture and then think about concrete policies and other reforms that could be proposed on the issues discussed. And his vision included a student fellows program, which would involve current NYU law students in these activities. In many ways, the inspiration for all of this was the Martin Lecture that Judge Katzmann himself delivered at the New York Bar back in 2007. That lecture was entitled "The Legal Profession and the Unmet Needs of the Immigrant Poor." And in that lecture, Judge Katzmann put a spotlight on the lack of legal representation in many immigration cases in the federal courts and on the consequences of that lack of representation. After he delivered the lecture, a study group was convened to examine the issue more deeply and to suggest solutions. The ultimate result, thanks to the hard work of many and the generosity of some key funders, was the creation in 2014 of the Immigrant Justice Corps, which now provides legal representation to people in immigration cases within the Second Circuit. Their work, which is directly traceable to Judge Katzmann's vision, has had an immense impact, and it's inspiring similar initiatives across the country. Now, Judge Katzmann's idea was to replicate that model here at NYU with an annual lecture, study groups, plus the innovation of student fellows, all leading to impact. It was a brilliant idea, and we were thrilled that he would implement and lead this initiative here at NYU. But then tragically, Judge Katzmann passed away in June of last year. This, of course, was an immense loss for everyone who knew him, and also for the law and the country more broadly. One dimension of the loss is that we were deprived of the opportunity to continue to learn from Judge Katzmann in his capacity as convener of this new lecture series and its associated activities. Instead, we have resolved to push forward with his idea and to do it in his name and his honor. In doing so, we are extremely grateful for the support and engagement of many people, including especially Judge Katzmann's widow, Jennifer Callahan, his brother, Judge Gary Katzmann, and the rest of the Katzmann family, along with many dozen former clerks of Judge Katzmann who have agreed to serve on program committees for this initiative, and also on a mentors committee to support the NYU Law Katzmann Student Fellows we will select on an annual basis. And speaking of the Student Fellows, we are grateful to them for the excellent work they have done to help us prepare for tonight's event. Let me name those Student Fellows. The first class of NYU Law Katzmann Fellows are Sasha Boutillier, Brian Cross, Jamie Fofana, and Louisa Leal. They've done outstanding work. Finally, and certainly but not least, we are grateful to the donor supporters, all admirers of Judge Katzmann, who have thrown their support behind this initiative to create an endowment that is sufficient to support the annual Katzmann Lecture, as well as all the related activities, study groups, student fellows, and the like, that will make up what we will call the Katzmann Symposium. With that, I am honored to welcome virtually to NYU Law our inaugural Katzmann Lecturer, Justice Sonia Sotomayor. Justice Sotomayor needs no introduction to any audience. She is a hero to millions in this country and around the world, and is a singularly powerful voice on today's Supreme Court. What some in our audience tonight may not know, though, is that she was also for decades a very close colleague and friend of Judge Katzmann's. In fact, it was his idea to invite her to be our inaugural lecturer, and I know he would be so pleased to see her here with us tonight. Justice Sotomayor, welcome.
Sorry, Trevor, it takes me a second to deal with technology.
There you
Hello,
are.
everyone. I'm so delighted to be here. I'm obviously sad that my brother is not physically here, but I know he's watching from above. I have to tell you, as I prepared for today's talk, I kept thinking of all of the conversations I would have had with him if he were with us. But I know that I, as well as so many others, were so deeply touched by him during our lives that I hope some of his concerns will come through my voice.
Thank you. We do all miss him tonight, but it's a good occasion to remember him and to be inspired by his vision to carry it forward. And part of doing that is in tonight's theme. Our theme for our conversation tonight, which will, instead of a formal lecture, we will have a conversation, the Justice and I, is judicial independence. And that topic was chosen by Judge Katzmann himself. And so in seeking to carry his vision forward, we are sticking with the topic that he chose for the inaugural event. It is, of course, an immensely important topic and a complicated one. And I look forward to hearing, Justice, your thoughts on it this evening. So why don't we begin? We could start by trying to define judicial independence. It's not necessarily self-defining. Judge Katzmann himself once described judicial independence as having at least two forms or dimensions, something he called decisional independence, which refers to the ability of individual judges to rule on cases without fear of retaliation. And then secondly, institutional independence, which has to do more with the freedom of the judiciary as a whole from pressures or undue pressures from other branches of government. Do you see it that way, Justice, or how would you define judicial independence?
Trevor, as you noted, few in their lives have been more devoted to or more a careful student of the judiciary as an institution than my brother, Bob Katzmann. I would be foolish indeed to question his thoughts, so I don't. I fully adopt Bob's two-part matrix for structuring our talk about judicial independence. And this is a lecture, so I'm going to be doing some sort of teaching in the process, but also expressing my thoughts. So for the general public, they don't realize that the Constitution does deal with judicial independence in its own ways, particularly decisional independence, by giving Article 3 federal judges lifetime appointments. Our salaries can't be reduced during our tenure. And the Constitution provides that we can't be removed from office only by impeachment and conviction for bribery, treason, and other high crimes and misdemeanors, and by 2/3 of the Senate majority. Those are powerful protections for individual decision-making. Additionally, however, there are judicial codes of ethics which help reduce decisional pressures by requiring judges to recuse themselves from cases involving family members, from matters they previously handled as lawyers, or from matters involving entities in which they have a financial interest. So one can imagine the kind of pressures that would exist if you were dealing with people you know in making decisions, or if you're financially indebted to anyone. These explicit constitutional provisions and judicial conduct codes directly support structural decisional independence and create a legal doctrine for independence. But alone, they're not enough. To protect the second form of judicial independence, institutional independence from the other branches of government, we need something else. Although judges' salaries cannot be reduced during their tenure, there is no explicit constitutional provision that sets or protects the court's budget. That is left entirely to Congress and the executive in the budget-making process. And it doesn't take much for people to understand that's a big threat against any entity, or could be. Similarly, no explicit constitutional provision prevents Congress from depriving the courts of jurisdiction to hear cases. No constitutional provision explicitly obligates the other two branches of government to follow the court's decisions. Nor does the Constitution protect judges from political influence in their selection. To the contrary, everybody knows federal judges are appointed by the president and confirmed by the Senate. Many other countries do it very differently. England, for example, has laws setting forth the qualifications for judges. The Queen, on the advice of the Prime Minister, selects judges, but from a limited list of people recommended by an independent judicial appointments commission made up, I think, almost exclusively of judges. The commission is required to confer with some government officials, and a limited veto power of the commission's choice exists. But by statutory directive, judicial selection is required to be on the basis of merit and structured to be protected from political influence. So, how do we here in the United States create what Bob called institutional independence in the US, when we as a nation have chosen to protect judicial independence primarily by norms? I'll bet norms that the nation has largely followed, and up to this point in our history, largely supported. Congress has never used the power of the purse to blackmail the court or to do its bidding, and has traditionally allotted the court the funds it seeks for it to function. Now, during the Reconstruction era, Congress stripped the court of jurisdiction to review the Reconstruction Acts because it feared our court would declare those acts unconstitutional. But since that time, Congress has stripped the courts of jurisdiction in discrete areas like certain immigration law disputes, or given executive agencies, initial review of many matters. But Congress has generally accepted independent judicial review of controversies. It permits the court to do its work. Finally, only twice in our history have precedents ignored Supreme Court rulings. Imagine that. For 2 years, 100 years of history. First, Andrew Jackson permitted states to displace Indians from their sovereign lands and gave them federal support to do so, in direct contravention of a Supreme Court ruling in Worcester versus Georgia, holding that Indian nations were sovereigns and states could not pass laws controlling Indian lands. Second, Abraham Lincoln suspended the writ of habeas corpus, defying a ruling of the court that the writ could only be suspended by Congress. In that case, Congress later avoided a continuing confrontation with the courts by authorizing presidents to suspend the writ during a crisis. Now, when FDR moved to add justices to the Supreme Court in order to secure the court's approval of his legislative agenda, a Democrat-controlled Senate, the public and the media defeated his attempt. Our norms respecting the importance of judicial independence have been central to the survival of our nation and generally have been adequate to protect institutional independence when it has been challenged by the other branches. It is an aspirational goal, not a legal norm, but one so far with a lot of bite in our history.
Thank you. That's a wonderful opening. And I think especially important for people to understand that other than the few constitutional protections that you pointed to, which presumably are legally enforceable in the right context, almost all of what we think of judicial independence entailing in this country is at a level of more informal norm, established maybe over the course of years, decades, even centuries, but norm. And we know that norms can take a long time to be built up and yet may be frittered away quickly if not attended to.
Yes.
One thing we sometimes ask when speaking about judicial independence is, what is it for? Is judicial independence an end in and of itself, or is it a means to certain ends? And various of your colleagues, as you know, have spoken and written about judicial independence over the years, offering some thoughts in seeming answer to that question. For example, Justice Kennedy has argued that the judiciary needs to be independent from political pressures because judges must sometimes make unpopular decisions, politically unpopular decisions, though they are constitutionally correct, so that independence is a means to the end of the court being able to do that work. Justice Breyer has said that the framers' goal in creating an independent judiciary was to help establish legal impartiality and to protect the rights of minorities. Justice Scalia once argued that judicial independence is valuable really only if and as long as judges act as neutral arbiters, as opposed to implementing their own personal views. So it seems that Justice Scalia felt that the more judges act as policymakers, the less they deserve to be granted independence. How do you see it, Justice, in terms of what underlying goals judicial independence is there to serve? And if you're willing, what do you think about what your colleagues have said on the topic?
Well, I agree with all of them because I don't think they're necessarily contradictory. Mm-hmm. Most people don't understand that we're not a democracy. What democracy means is a majority of the people voting in a particular way and setting the rules for everyone. Instead, we are a constitutional republic in which all three branches of government are limited in their powers. The court is charged with monitoring those limits for both the other two branches of government and even for ourselves. The Bill of Rights explicitly sets forth things that the government cannot do, even if approved by Congress and the president as representatives of the people. Courts and judges are going to issue unpopular rulings under the Constitution. It's just a given. Once you give us the power to say what's unconstitutional, that is going to be the end result. Someone's going to be unhappy. Now, some would say we gave ourselves that power in Marbury versus Madison. I'll talk about that later. But the point is that that's the structure that we have accepted for over 200 years. Now, once Justice O'Connor said that judicial independence is hard to define, she reinvented an old phrase and said, it's hard to define it, but I know judicial independence when I see it. In her speeches and in many that Steve Breyer has given, they both have pointed out that judicial independence is often independency is often easy to spot. Justice Breyer talks a lot about telephone justice, referring to countries where politicians call judges and tell them how they must rule. There are countries where judges are threatened with violence if they do not rule in certain ways, or where uncontrolled bribery has become the endemic in the judicial system. Justice O'Connor once told the story of a country in which its president's security force killed the chief judge's beloved cat after the judge ruled against the president. It's easy to say bribery, coercion in any form, direct interference with judicial making. They will all break down the public's belief, but not just in judicial independence, but in the government as a whole. I believe the public will likely conclude that its governing bodies are ruling in their own self-interest and not for the public if those things exist. What I believe Justice O'Connor was saying is that the reasons for judicial independence are self-evident. If the public does not perceive its judges as impartially rendering decisions, whether popular or unpopular, there will not be continued support for the norms that keep the judiciary independent.
Now, you've touched on this a little already, but wonder if you might say a little bit more about who or what is responsible for achieving and maintaining judicial independence. Is it the Congress? Is it the president? Is it the court itself, the press, the people more generally? We understand the importance now of judicial independence, but whose job is it to make sure we don't lose it?
It's every actor's job in our society. We are all, every actor, Congress, the public, the press, the court itself, everyone is equally responsible for achieving and maintaining judicial independence. It doesn't exist without all of us. No one sector has more or less responsibility. Through our history, every actor in our society has played vital roles in maintaining judicial independence. When President Jefferson lobbied to have the first and only Supreme Court Justice Samuel Chase impeached, a Senate made up of both Federalists and Jeffersonians acquitted him. Even though Justice Chase was an avowed Federalist, and even though he had spoken out intemperately against President Jackson's ideas. President Lincoln, as I noted before, ignored a Supreme Court ruling that only Congress had the power to suspend the writ of habeas corpus. And as I said, later Congresses averted the long-term repercussions of ignoring Supreme Court directives by giving presidents authority to suspend the writs in emergencies. FDR's proposal to add judges to the court to assure his own agenda was blocked by Democrats, as I noted, and by an outcry of public and media opinion. There are other reported examples of presidents who have contemplated not following Supreme Court rulings. I'm not going to talk about the recent ones. For example, President Eisenhower hesitated to use federal forces to integrate schools in the South. Thought about it, investigated it. But we all know the rule of law norm withheld that challenge. Everyone remembers the Norman Rockwell painting of Ruby Bridges, an African-American school child being escorted to her new school, flanked by federal agents. Without all sectors of our society understanding the importance of our shared responsibility to protect judicial independence, it will and cannot survive. Now, threats to judicial independence historically have come from different actors for different reasons. But our belief in judicial independence has nonetheless triumphed because other actors have taken up the mantle of defending us. I hope that continues.
Maybe we could talk about a related, in some ways, contradictory idea to judicial independence, and that's judicial accountability. These days, in particular, there are some critics of your court who want the court to be more responsive to what those critics take to be the values of democracy and to the will of the people. And so they invoke the idea that even a judiciary such as ours, which doesn't stand for election or re-election, still must be accountable in some way to the public. what do you think about the relationship between ideas of judicial accountability and the powerfully important norm of judicial independence as you've been describing it?
Trevor, I've already noted we're a constitutional republic. Our founding fathers explicitly rejected a democratic model of government in which only legislatures determine the constitutionality of their laws. Some nations do not have a Bill of Rights protecting their citizens from certain acts of the majority. We elect our president through the Electoral College, not by majoritarian rule. Our Congress gives each state, despite its size or number of people, equal representation in the state. I don't believe the court can or ever should sacrifice the limits imposed by the Constitution on the government's ability to bend to majority rule. What is the people's will is a hard question in any event. We know that a majority of Americans may well believe differently on certain issues than their elected officials. Look at recent polls on hot button issues in America. It is hard for me to subscribe to a view that judicial accountability needs to come at the cost of judicial independence. To the extent any branch of our government, press, or public believes it must, I fear we would be on the road to destroying the very core of judicial independence that we value. And so I don't think the two should be seen as conflicting one another. They have to be seen as complementing one another.
So that to the extent there will be to figure out a way to do that without compromising judicial independence. That's what I hear you
exactly.
saying. A related topic is the question of judicial independence and partisanship, political partisanship. I think few would disagree that the present period is one of especially intense political polarization. What's the relationship between judicial independence and extreme political polarization? How does judicial independence fare in such times?
We have had extreme partisan times throughout our history. The Federalists and Jeffersonians at the beginning of our founding were extremely polarized. In 1801, Congress reduced the size of the Supreme Court from 6 to 5 to deny President Jefferson the power to appoint a new justice. Congress did a similar thing in 1866, reducing the court from 9 to 7 justices in order to limit President Andrew Johnson's power to appoint new judges after Lincoln's assassination. All these laws were reversed very quickly, largely in part because of the fluidity of political control, with different parties alternating fairly regularly the control of Congress and the presidency in a continuous manner. Today, polarization has new foundations that can put judicial independence at greater risk. With modern gerrymandering, political parties are able to set voting districts in ways that entrench themselves and their party in power in ways never known before. Gerrymandering means that how much change will occur on a regular basis between political parties in many states and congressional districts is unknown. To the extent the political party wants to entrench its views of proper judicial outcomes, it is easier to do so now because the views of judicial appointees on many issues is so well known. The internet has been a blessing in many ways, but it also permits both the public and appointing attorneys to review the entirety of a person's writings and determine whether that person's approach comports with their views or views that they endorse. Finally, and relatedly, I think for the first time in our history, the mantle of judicial philosophy has become tightly interwoven with political parties. For almost all of our history, political parties debated what was the best way to govern. You just have to look at the debates between Federalists and Jeffersonians on whether state or national power should be given precedence. Political parties rarely discussed the issue of the best way to approach interpretation of the Constitution and statute. That discussion was largely an academic exercise. Now, political platforms have adopted the language of judicial doctrines as a way to control outcome in cases. But dangerously, the back and forth that comes in academic debate that goes into looking at the strengths and weaknesses and costs of different doctrinal approaches is a nuance the public is not taught by political players. It becomes an issue of slogans rather than the public fully appreciating what it means to do approaches in one way or another. Chief Justice Rehnquist believed the country cyclically had threats to judicial independence, and he pointed to the Chase situation and the McCready situation, another one, and the FDR situation. But in each situation, he said, the nation always met the challenge and that judicial independence continued to thrive. I hope he was right, that we will survive the new challenges. But I do have concerns that the new strains on it may be as harsh and costly as our polarization has been on our government's functioning. It could cost us a lot.
You've already referred to this, but the Senate confirmation process for Supreme Court nominees and even lower court judicial nominees has itself become increasingly partisan. The divisions along party lines seem deeper. The prospects for the members of the party opposite to the nominating president casting any votes in favor of a nominee seem increasingly dim. Does that have an impact on the extent to which the court itself is independent of politics? It might be a process that we lament, but it might not have a great effect on the independence of the court once those who are nominated get through that process and join the court. Or maybe it does have an effect, or at least an effect on the appearance of the independence of the court. What do you think?
Surely it has an effect on the appearance of the impartiality of the court. As you noted, we are far from the times when Supreme Court nominees would receive nearly unanimous approval, even in divided Congresses. And the more partisan the voting becomes, the less belief that the public is likely to have that Congress is making a merits-based or qualifications-based assessment of judicial nominees. Is it going to affect directly the court's functioning? It could. Many academics have pointed to the fact that in more recent times, circuit courts are reviewing panel decisions in many more en banc reviews. For the audience who doesn't understand that, I come from a circuit which during my time there believed that the three judges who heard a case were doing the best job they could, coming to the most reasonable decision they could. And that even if you disagreed with them, only in extreme circumstances would you ask the entire court of judges to review that decision. And so in my time on the court, maybe one or two en banc proceedings happened. That on the Second Circuit and in other courts, circuit courts, has changed dramatically. Many who view this situation think it has something to do with the partisan nature of the appointment process. I hope not, but it certainly does feed into the public's uncertainty, and that has a price.
Can you say more about that, the perceptions of the public, the extent to which the public perceives the court and the judiciary more broadly as independent. Do you think that an ebbing of the public's confidence in the independence of the judiciary, even if it's wrong, does that pose a threat to the actual functioning of the court and to the role of the court in American life?
Sure it does. We talked about the norm of following judicial opinions. To the extent that our political branches have followed that norm and that the people have followed that norm is attributable in large measure to their belief that we are independent. That alone could be at risk if the public starts losing confidence in us.
Presumably, if the public, that is the voters, stop believing that the court is independent, then the political price to elected officials of not upholding the independence will go down. And so in that sense, a threat could arise, just as you said.
Exactly.
And what about the court's power over its own independence? I don't need to tell you that the members of your court and federal judges more broadly agree on some things and they disagree pretty deeply on others. Many espouse very different ideas about how the Constitution should be interpreted, how the present court should relate to its precedents. Given those disagreements, do judges also tend to value judicial independence the same way, or is there deep disagreement on even that seemingly fundamental issue?
Justice O'Connor once said that no judge ever perceived him or herself as interpreting law arbitrarily or by whim. I think every judge prides themselves on being bounded by the law and its legal norms. Dare say that you would never read a legal decision in which any judge says, this is the right thing to do, period. Every legal decision is explained thoroughly, and it's explained based on well-recognized principles of interpretation and judicial norms. So I dare say that no judge, or virtually no judge, has ever questioned the essence of Bob Katzmann's view that we as a society prize both decisional and institutional independence. I doubt any of us fails to value that. We differ, however, on what best promotes judicial independence and how it affects the public's perception. For example, you alluded to this, some judges believe that following precedents gives stability to the law and protects the courts from being viewed as beholden to either the president who appointed them or to the party to which they belong. Others believe that getting the law right under the Constitution unmoored to precedents they feel were erroneous fulfills their constitutional obligation to interpret the Constitution faithfully. Justice Scalia and some of my colleagues, current colleagues, say the court staying out of social issues will best foster public views on our independence. Others believe that social issues often drive majoritarian laws that impinge on the rights protected by the Constitution, and that courts have no alternative to address those questions. Now, few would claim that the court was wrong in ruling in Brown versus Board of Education that segregation violated the 14th Amendment of the Constitution. That's what was a social issue. Social issues are not picked by the court. They come to the court. How we view the Constitution as set out in its works, in our practices as a nation, in our precedents, and from what constitutional experience has taught us, typically explains how we deal with disagreement. We explain our thoughts, views, and approaches to each other in our conferences and in our writing. It is a pity that most people in the public, including elected representatives and perhaps some journalists, they don't read our opinions. If they did, they might realize that outcomes they think are easy almost always present closer questions than they imagine, with pros and cons on both sides that need to be carefully evaluated. You know, whatever judicial philosophy or approach you adopt has potentially negative consequences.
Mm.
And the public should understand that before they choose a side. We need a public who will actually understand what is being argued, and that doesn't concentrate on the outcome of cases.
I think your point here is a very important one, that sometimes disagreements among judges, between and among people, may be at the level of ends, disagreeing about ultimate goals. And sometimes they're really disagreements about means. And when it comes to judicial independence, it seems right. I think you must be right that surely virtually all, if not literally all, judges value the independence of the judiciary and see it's important to their own work. The question is how to achieve it. And that's where we seem to get the disagreements that you've been discussing.
Absolutely, most certainly.
Now, if we're talking about the court's role in fostering its own independence, I suppose we could look at some doctrines that the court has evolved over time that limit the extent to which it will become involved in certain kinds of cases. I'm thinking of the political question doctrine, for example, which counsels that the court may have formal jurisdiction in an area, but perhaps even as just a prudential matter, perhaps as a constitutional matter, should not get involved in certain kinds of inter-branch disputes between the legislature and the executive, or matters that are just entirely left to another branch. Or even standing doctrine, which might limit the ability for the court to hear a case that would seem to call upon it to oversee the actions of another branch of government in ways that go beyond ordinary adjudication of cases. I'm not asking you to state your views pro or con on those doctrines generally, but do you see those as representing important ways for the court itself to maintain independence by not getting too involved in conflicts with other branches, or is that not how you would see that?
There's not a yes or no answer to that, Trevor. Obviously, something like the political question doctrine clearly arose from a belief by the court that there are certain political questions that should not be subject to review by the court. And that motivation arose largely in questions that the court understood it couldn't play a role in choosing sides, that had to be something that would be done by the two other elected branches. Other doctrines, and all of these doctrines are in fact created by the court, doctrines that narrow the times that courts will hear situations, that in part is driven by the Constitution's command that we should only decide actual cases and controversies. But each time the court recognizes a doctrine, it has to be very careful to strike a balance. Because if it goes too far one way or too far in another, for example, in telling too many people that they don't have standing to bring their inflicted harm to judicial accommodation, the public is going to stop thinking that the courts are there to protect them in any way. And so there's a cost when we go too far in judicially creating exemptions to our ability to hear cases. And so there is a danger in us proceeding down a path where the balance is not properly struck. Or acknowledged, I should say.
Now, putting these last two topics together, what the court can do about its own independence and the particular concerns around political polarization, I think I heard you earlier to say that with respect to political polarization and the current moment and the continued health of some of the key elements of our constitutional republic, including judicial independence, we may be in or near a crisis moment, but I don't want to put those words in your mouth. I wonder if you would agree with that characterization. And if you do, what can be done either by the court or by other actors to protect against a deepening of that crisis, if you see it as a crisis?
Big question, long answer, not a simple one. Yes, I have concerns that we might be in crisis. As norms in the nomination process are broken, as more senators, congressional representatives, governors, mayors, local politicians, and the media question the legitimacy of the court, many of them heap scorn on the court. And it's claim us to be nonpartisan. The threat is greater and unprecedented than any time in our history. I am, like my colleague Stephen Breyer, an optimist who believes in the great experiment our country is, and that we will endure. Yet, as Benjamin Franklin said, when asked what type of government the Constitutional Convention had forged, he responded by saying, "A republic, if you can keep it." For our republic to endure, we need public education focused on understanding both our system of government and what makes it work, what its limits are, and the checks and balances of our tripart equal branches of government. Every justice appointed by Republican and Democratic precedents has emphasized the importance of civic education in supporting judicial independence. Justice Sandra Day O'Connor, appointed by President Reagan, founded iCivics, which teaches students about civic education and aimed at revitalizing civic education in our schools. I now sit on the board of that organization, and I was appointed by President Obama. Justice Neil Gorsuch, a President Trump appointee, and I have spoken frequently together and in a lot of different occasions on the importance of civic education and participation. We need the public to hold its elected officials accountable in respecting the judiciary and its work. We can only do it if the public understands the importance of our independence to the survival of the nation. You know, it is strange indeed that virtually every media account today announces a Supreme Court decision by noting the justices' votes by the political party that appointed them. Few media accounts report on the nuances of thinking that often divides the judges appointed by similar precedents of the same party, or that lead in some cases to unexpected alliances between judges appointed by different parties. We all have a civic responsibility to avoid rhetoric, to inflame people against each other in our institutions. And we must engage in serious, thoughtful conversation about what works and may work better in our judiciary. That's why Bob chose this topic, because he believed in that so much, as I do. Now, what can the court itself do to safeguard its independence? Every judge knows that one of the most important ways we have of protecting our independence is by writing careful and thorough opinions explaining our decisions. Even though I believe it is true that most people do not read our opinions, setting forth our interpretations and what supports them can be used by others authorized to seek change, to change the law if they disagree with us. Congress or the public, if they believe we got it wrong, can work at changing our interpretations of laws. Maybe not of the Constitution, but certainly of laws. It happened with the Lilly Ledbetter Fair Pay Act, following Justice Ruth Bader Ginsburg's dissent in that case. For those in the public watching who don't understand that case, what happened there, the court ruled that Lely Ledbetter, who had been paid a differential salary for years only because of her race, she was equally qualified to everyone else, wasn't permitted to recover damages by the court because it viewed a statute of limitations as limiting her recovery. That case, obviously, the public understood that finding out that you're paid less than others can sometimes take a very long time. And you shouldn't be precluded from recovering what you fairly worked for. And hence her Fair Pay Act legislation. Further, the clarity of our arguments can affect the thinking of future generations of judges. Justice Harlan's dissent in Plessy versus Ferguson, condemning segregation as violating the 14th Amendment, won the day over 50 years later in Brown versus Board of Education. But judges also must always be sensitive to the public's perception of their interactions with public officials and their representatives. Most appointed judges have friends and people they know in the political arenas. Ending relationships is not required, but care by judges in ensuring that contacts do not give the impression of undue influence or endorsement is necessary. We must also be sensitive to not prejudging cases and speeches. We have a wonderful vehicle, our opinions, to set forth our judicial views. Speeches on legal issues, if not done carefully, can give the appearance of undue influence by groups we choose to give speeches to. We need to be careful. The history of the court, but if I can tell you what I think is the most important aspect of what judges can do to support judicial independence, is to keep open minds. The history of the court has been filled with justices changing their doctrinal views over time. Harry Blackmun once said, a justice should not come to the court with his constitutional views fully developed, and it would have been disappointing to him if a justice over time in his work did not grow and change. Now, Justice Blackmun was appointed by Richard Nixon and was viewed as a Republican conservative of the time of his appointment. He was called the Minnesota twin to Justice Burger, with whom he was friends. Justice Blackmun voted consistently to uphold death penalty laws in the 1970s after his appointment, but by the 1990s came to believe that the death penalty as administered was unconstitutional. Big shift. Justice Stevens also was appointed by a Republican, President Ford. He had written opinions as a Court of Appeals judge, challenging the existence of substantive due process. He didn't think it existed. In a speech he later gave at Fordham University that I attended in the 2000s, he explained why he had changed his mind and had come to believe that substantive due process was inherent in the constitutional structure. Another huge change. For me, most importantly, I think each judge on every court has to remember that we have an obligation to keep open minds that are willing to change with time and experience. If we don't show it, people will believe, perhaps wrongly, that we are just political creatures and not independent judges. One of the judicial attributes that the public over our history has come to appreciate is that justices have never voted consistently with the views of presidents or parties that appointed them. So, for example, Justice McReynolds was appointed by a Democrat, Woodrow Wilson, but he became one of the so-called four horsemen that voted against nearly all of FDR's New Deal legislation. Another of the four horsemen, Justice Roberts, not the current one, switched votes to uphold minimum wage legislation, and it is said that he thereby helped to defeat FDR's court increasing plan. Yes, consistency is critical to stability in law, and the public's perception of judicial fidelity to law and not to outside influence is critical. Yet, I believe the public appreciates growth and development in thinking. We have institutional setups now that might affect how willing or disposed judges are to change. The emphasis to pick nominees with extensive writings and publicly expressed views on precedents of the court can be viewed by the public as ways to control a judge from changing his or her mind. And it can also stifle the growth of a judge. Similarly, we now have organizations whose memberships center around judicial philosophies. And to the extent that those organizations supply the friends and employment support for judicial nominees who think in the same way, that too is likely to make view growth more difficult. And the public's perception of independence less sure. I hope, however, that as our prior justices understood that views should change in light of the way the law developed and created tensions with other constitutional principles, that we as justices will continue to grow and will protect the public's belief that we are truly independent, even from our own previously fixed views. You know, I think personally that every litigant who comes into a court has a dream that their arguments will change a judge's mind. If we destroy that dream, I think we've destroyed an important part of people's faith in the judiciary.
That's really powerfully put, that judicial independence includes a measure of independence from your own prior self.
Exactly.
We have just a few minutes left, Justice, and if you'll permit me, I wanted to put in front of you a couple of critiques of judicial independence. I guess most directly and impolitely put, it would be whether the court really deserves the independence that you and I have been talking about. Some critics have suggested that the independence and indeed even the authority of the court is worth preserving only to the extent that the court functions effectively in protecting groups that are most likely to be marginalized by majoritarian democracy, what the Supreme Court in the famous Caroline Products case called discrete and insular minorities. That's the court's key function, and its independence is worth preserving if, but only if, the court is effective in protecting those who would be most vulnerable to oppression by majoritarian institutions. So to what extent has the court over time earned its independence by living up to that role? Or I suppose to put it another way, what actually is the capacity of the court to protect the most vulnerable in our society?
Trevor, that is such a huge question. Because you do have to understand the court's history. And maybe it goes, in answering, I have to go back to what I said earlier. Every actor in our society has a role. And that role not only includes supporting the judiciary, but in supporting the people of our country. The court and the critics, and I understand where they come from, perhaps except in Brown versus Board of Education, the court generally has been behind in time in viewing changes that protect people. So if you think of the right to vote, it wasn't recognized in women until there was for women until there was a constitutional amendment. And the court was way behind the Congress passing Title VII and Title IX to protect women from discrimination in the 1960s. We didn't have our first case, really, protecting women and their rights to participate in our society until Justice Ruth Bader Ginsburg was it the 70s, the 60s. Title VII and IX were in the 60s. It wasn't until the 1990s and Justice Ruth Bader Ginsburg joined the court that the court had the first case in which it ruled in favor of a woman's claim of discrimination. And that was in the BMI, Virginia Military School, the Virginia Military School case. So a long time in which the court didn't act to protect women. Now, there are many who say that the court led the society from where the society was at the time in reaching integration. That most of our country wasn't prepared to accept Brown. And in fact, Stephen Breyer has pointed out that it took us almost 12 years later to reach laws that prohibited people of different races from marrying. And he says some of that hesitation in the court was probably recognition that the country was in strife about racial integration, and that the court had to proceed somewhat more slowly than perhaps we should have. But there have been some academics have said that this issue was one of the court's creation. We are the ones who passed Plessy versus Ferguson, and some think that that was instrumental in creating the circumstances of the Civil War. And that segregation was legitimized by the court in Plessy versus Ferguson. And if the court had done its duty back then and read the Constitution according to its terms, we wouldn't have had to deal with segregation. So I guess I'm pointing out to people that relying on one of our institutions to protect people is a misplaced expectation. That we can't believe that there is only one part of our society that can protect us. It has to be a joint enterprise by all segments of our society.
Well, Justice, left to my own devices, I'd continue the conversation for 4 more hours at least, and I'm sure our audience would love that. But we've run already past our hour. I do want to thank you on behalf certainly of myself and our law school, but also the larger Bob Katzmann family of clerks and colleagues. There could not have been a better inaugural Katzmann Lecture than this event tonight, thanks to you. This has really been insightful and thought-provoking. And given your day job, we are so grateful that you've taken time to honor Bob Katzmann and all of us with your words tonight. Justice, thank you. If not for COVID, we would have been doing this event here at the law school, and you right now would be in the midst of hearing a standing ovation, I'm certain. But in the absence of that, thank you very much, Justice, for being with us this evening, and thanks to everyone who joined us for this special event.
Thank you, Trevor.
Good night.
Good night.